and welcome to a Newsflash episode of Unpacking the Case, the podcast by Davitt, Bould, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape.
Hi, Richard.
Hello, Lizzie, and how are you?
I'm very well, thank you. It's a Friday. We're here to talk about another case, this time a Court of Appeal case from the 19th of May. And the case is called Great Jackson Street Estates and Manchester City Council. And it's revisiting something we've talked about a few times, which is discharging and modifying restrictive covenants under Section 84 of the Law and Property Act. Do you want to start, as usual, with a bit of background on this one?
Yes, if I will. Well, it all took place in Manchester, the background, as you can imagine. It's in a regeneration zone just to the south of the city centre. And if you know Manchester, like Lizzie and myself know it, then it's, been for many a year, Manchester's undergoing major redevelopment. It's the whole area, not just this particular property. The plans are to build 25 tower blocks, 7 of which are going to be over 40 stories and 71 stories in height, which is high. So they're always going to be flats and the like, some major redevelopments around Great Jackson Street. But on this particular occasion, it involved a couple of redundant warehouses which were on long leases from the City Council, the predecessors to Great Jackson Street Estates had agreed originally a 99-year lease for these, 99-year lease for these warehouses back in 1978, and then it was extended to a 99-year lease from September the 29th, 1984, Michaelmas Day, if you didn't know. So it's got about 61 years left on the lease at the time of the hearing, and the plans were to demolish these 2 warehouses, which were leased out from the council, and build a couple of 56-story blocks, which is pretty high in its own right, with 1,037 flats and costing 300 to 350 million pounds. So it's pretty substantial, as you can imagine, Lizzie. And what was the sticking point, which gave rise to the upper tribunal and then to the Court of Appeal decision, was there were 11 covenants, restrictive covenants in relation to this particular property. The council actually wanted to negotiate a 250-year lease of the site, so they had a degree of control over it. And Great Jackson Street Estates didn't want this. They, sort of wanted to go ahead with development, which would necessitate either the discharge or, preferably for them, the discharge, if not the modification of these restrictive covenants. There were things like some of the covenants were sort of subject to the local authority's consent, but not qualified in relation, not fully qualified in relation to, the local authority couldn't unreasonably refuse consent. So the ones which were subject to local authority consent included things like you couldn't build over a sewer or any services, and you couldn't have anything other than 2 warehouses, and you couldn't build over more than 2/3 of the actual site. Other ones which were sort of subject to reasonableness, the local authority couldn't unreasonably refuse consent, included things like not cutting down any trees and shrubs and various other things besides, and others were subject to estate management, not to commit a nuisance or annoyance, not to put hoardings up. There was one, they had sort of typical commercial alienation covenants, which wouldn't be suitable for residential flats. But it was accepted, and it had to be that they couldn't question the alienation covenants. Remember, we did a case called Black Horse Investments in Southwark last year, which was all about that. Alienation covenants, you can only apply to modify or discharge under Section 84 user covenants or building covenants, so that was sort of quietly dropped. But again, as we mentioned in that Black Horse case before, you can apply to court to discharge and modify leasehold covenants if the lease was for more than 40 years in duration and at least 25 years have expired at Section 84.12. And so they made the application to the upper tribunal to discharge and modify these covenants.
And what did the upper tribunal decide?
Well, they tried in the upper tribunal on 3 grounds under Section 84.1a, which is where they're obsolete because of changes in the character of the property or the neighbourhood or other circumstances. That failed. The whole area has obviously changed since the 1970s, early 80s. Warehousing is not really appropriate to that area anymore. But the tribunal decided that you could have other users. It didn't have to be a 56-story tower block. So that failed. They also tried AA, which was the major issue. Tends to be the commonest to be litigated, which was a major issue in the Court of Appeal, that it prevents reasonable use of the land. It goes on to say in 84.1 capital A that it's doesn't have any practical benefits of substantial value or contrary to public interest. The upper tribunal decided that there would be prevented unreasonable use of the land, but there still would be a practical benefit because the council could dictate the actual building work and ensure it went ahead and safeguard the project and the likes. And the other one is that there's no injury, no one suffers loss, and that failed as well in the upper tribunal. So they went to appeal, and they added a ground in the Court of Appeal that it was purely about money. They just the council wanted to enforce these covenants so they could get sort of greater monetary value and giving you a 250-year lease at a higher premium and the likes. And that's what led to the May the 19th Court of Appeal decision.
So ended up in the Court of Appeal. What happened then?
Well, the Court of Appeal sort of largely agreed with the upper tribunal. They did say that whether there's a benefit of substantial value is fairly flexible and wide. The fact that you just want to control the operation wouldn't be a benefit, and if you did purely want sort of to use it to get additional money, if you like, that wouldn't be a benefit. But there was a public benefit, and it did secure sort of practical benefits, and it was in the public interest to dictate the developments when it occurred. That it progresses timelessly, and the developers don't suddenly stop halfway through and the likes. So it suited the public interest, and it had a practical benefit outside just any kind of monetary payment. The development had planning permission, subject to agreeing Section 106 agreements. But the Court of Appeal said that this gives you additional means of actually sort of controlling the development, and that's in the public interest, so the covenants weren't discharged. There was an attempt to modify the covenants as well, but that failed as well, basically because they were offered this 250-year lease, and you can modify covenants if they've been agreed, but they haven't been agreed. So that's it. It's an important case and a valuable case. So
what are the consequences of it, do you think?
Well, I mean, I think developers need to think hard about, if they've got leases, long leases, and building leases and likes, think hard about the terms of those leases in relation to development. And if it is in the public interest, then think carefully about whether they're going to be able to, because this case proceeds further. They're going to have great difficulties, discarding those covenants. What concerned me a little bit, and I can understand the decision more than understand it, is that they did have planning permission for these developments, and it gives you a sort of separate kind of right to actually dictate things regardless of planning permission. It does actually say in Section 84.1 capital B of the Act that you're supposed to have regard to things like the development plan and deciding to discharge and modify covenants, and also any declared or ascertainable pattern of grant or refusal of planning permission in the past. And there was a case, it's not exactly the point really, Alicia House, also Graham and Easington District Council, where the Court of Appeal back in 2009 sort of took into account the fact that the local authority had given planning permission as a way of the local authority acting unreasonably and refusing to discharge covenants. Well, I've got no problems with the decision. I think it's an incredibly significant decision. And I'll say, with all the developments that we have planned, in relation to long leases, just check your leasehold covenants.
Thank you very much, Richard.
My pleasure.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.